Welcome to the Top Texas Lawyers Podcast. This podcast is brought to you by the law firm of Abercrombie and Sanchez, PLLC. You can find us on the internet at astxlegal.com or by calling 1-888-981-7509. Your hosts are Bryan Abercrombie and Samuel Sanchez. Bryan has been practicing law for 18 years and is board certified by the Texas Board of Legal Specialization in the area of family law. Sam has been practicing for 13 years, is licensed in both Texas and Florida, and is a certified mediator. This podcast is for informational purposes only, and all views are the opinion of the hosts. It is not designed to provide legal advice for your particular legal matter, and it should not replace the advice of competent counsel. Welcome, and we hope you enjoy the Top Texas Lawyers Podcast. Good afternoon, and welcome to the Top Texas Lawyers Podcast for this March where are we at? 23rd, 2020 edition. With me, as always, is my co-host, Samuel Sanchez. How are you doing, Sam?
Not too bad. The chocolate to your chocolate chip cookie, I am assuming.
That's right. The flavor of life, Sam Sanchez.
Cinnamon in your coffee.
So we obviously, due to the unprecedented stuff that's going on in the world today, we're going to dispense with our previously scheduled podcast and talk about what's going on with cases and what's going on with this COVID-19 crisis we're all seem to be faced with. It's in every single state. It's involving just about every facet of your life. And if you're anything like me, Sam, I'm holed up inside my house with the wife and 2 kids, and we're doing homeschool and all that other kind of fun stuff. So
yeah, parents are definitely taking on a lot of different roles now.
Yes, I'm the principal, I think. I'm not real sure. I think my wife might be the principal, but homeschool is definitely a challenge. I definitely give a shout out to all the teachers out there in the world. You have an impossibly hard job, and it's very, very difficult. And if I didn't appreciate you now, or didn't appreciate you before, I apologize, and I certainly appreciate you now. But I think I've always appreciated what teachers do. They certainly don't get paid near enough for the job that they do for our kids. But all that said, let's talk a little bit about our topic du jour, or topic of the day, which is kind of how this COVID-19 is going to affect your civil case, your legal matter. And let's start cutting it up and see what we can do.
Yeah, no, I think that's a great idea. I mean, obviously, our last podcast, really, we had some great guests with us, kind of talked about it from the personal perspective. Still the professional perspective, but I would tell you legally there's some substantial things that are coming out. We can kind of break them down a little bit, both in Texas and Florida, because they're handling them differently. But both of these states have large cities, large populations. Not everybody is as quick to embrace the federal recommendations of social distancing. As other people are. Florida's a big vacation state. Obviously, Texas has our own coastline where spring breakers love to go. And so, a lot of things that are coming down from the Supreme Courts of both states are having substantial effect on how your legal matter is going to pursue. So I guess the first place I would recommend that we talk about, Bryan, is, okay, so let's say you've been thinking about filing. What are you seeing in Harris County, Montgomery County, the Houston area, in Texas, that courts are really saying, like, what can you get in? Can you get in at all? Should you file?
Well, what I've been seeing is, it's unprecedented. I mean, this has never happened. I've been practicing law for 20 years now, and I've never seen the Supreme Court issue orders, and they've issued 6 orders in the last, 2 weeks, Sam. I've never seen anything like it. They're trying to head stuff off at the pass, and they're trying to, this is an unprecedented crisis. And as I understand it, the CDC is trying to do everything possible to, stop this virus in its tracks because it's so contagious. And, you hear all this stuff on the news about flattening the curve, and, that's what it looks like they're trying to do with all this stuff. But with respect to your question, what I'm seeing is obviously courts are, for lack of a better word, kind of shut down or on hold, really. They're not shut down, but they're on hold. A lot of courts are trying to figure out what the next steps are. Right now, you can get in there if you have an absolute emergency. You can get in there. But short of an emergency, you're going to be on hold for a little bit until they figure all this stuff out. I mean, they're trying to take some unprecedented steps with, courts, via remote access or, via phone or Skype or, different things. I've seen, I think there was one judge up in Plano who was doing court via Skype from her home, right?
Yes.
It's unprecedented. I think courts are going to have to maneuver their way through this. But what I would tell, potential clients is no, they are tolling some statutes of limitations. They are tolling different things and they are resetting a lot of hearings. But I would tell you not to file. I mean, still take care of the legal work that needs to be taken care of. Go ahead and get your filing, but just understand that you might have to be patient with getting potentially a hearing before the court.
Yeah, same thing up here in North Texas, and I would tell you in South Florida, very similar things. Obviously, 254 counties in the state of Texas, all of them by Governor Abbott's declaration in a state of disaster. What does that really mean? Well, like what you said, Bryan, the constitutional limitations that are typically going to be at play in your case, which may be like deadlines to respond, if you elect to have a jury, all these kinds of things that are constitutional rights are for the time being suspended or delayed. And so, but if you delay your filing, what we're seeing is that the queue is continuing. And so what I mean by that is it's like getting on a call, let's say you're calling, I don't know, the doctor's office and they tell you let's say your license plate and they're like, hey, we're going to take the calls in the order in which they were received. Well, your filings are really being handled the same way by most counties in all these states, which is saying you get in line and don't step out of line, because if you step out of line, your place in line is going to be filled by somebody else. And so, the more that people kind of waffle or hold and say gosh, I really want to wait, they can just expect longer waits on the tail end of this rather than being already in the queue.
I would agree. I think if you have a legal matter, you feel it's important, I wouldn't, just understand that you're going to have to be patient on the side, with working with the courts. But as far as filing goes, I mean, obviously in Texas, we can e-file. So you don't even have to appear in court to file something, unless you're a pro se client. But that's a totally different ballgame. But, attorneys can file things online. Obviously phones and all of the stuff that we have are still available. And that's all. Let's talk a little bit about the different types of actions that we could be dealing with. I mean, let's talk. Obviously, you and I are both skilled in family law, so let's talk a little bit about how family law is affected. Let's talk about let's talk a little bit about. I know Tarrant County. This morning they issued a standing order, which it's a kind of a joke amongst lawyers because every county just about that we practice in has a standing order except Tarrant County, and we were talking for years and years about Tarrant County adopting a standing order or coming up with a standing order, and they didn't do it, and they didn't do it, and they didn't do it, and now it takes this kind of natural disaster for them to issue a standing order. But it's a good thing. I think it helps keep the status quo. I think it does help everybody working and playing well with others. And let's talk a little bit about standing orders.
Yeah, I think that's going to be really important about understanding the effect of a standing order in anticipation of filing, or if you filed and you're currently under a standing order, what does it typically do?
Let's talk a little bit about what a standing order is, so that everybody kind of knows the inside baseball of standing orders.
Sure. A standing order, think of it, the best example that I can give people is that a standing order is really like a Polaroid picture, right? So think about taking a Polaroid, and I know most of our listeners are probably way too young for Polaroids, but if they're not, you used to take this picture, it would slide out basically a cardboard based photograph. You would shake it around until it dried, but once it dried, it was set. You couldn't change it. It wasn't a digital image. That's the same thing that a standing order is. A standing order really takes into effect the second that somebody files. And it's usually standing orders are mutual upon service, meaning that if you file, it instantly is an effect on you. The second that you serve the other party or they execute a waiver of service accepting that order or that the process has begun, then that order takes effect on them. And when I say that it's a Polaroid picture, nothing can change. Really, that means nobody's going to empty out bank accounts. Nobody's going to run up credit card debt. Nobody's going to have a bonfire in the backyard or garage sale in the front yard. we're going to behave for 14 to 21 days, depending on these relaxed deadlines. Nobody really knows those. But I would tell you that the standing order applies through the entirety of the case. So those are protections for both persons and property, right? So that means we're not going to threaten or harass each other. We're not going to, call 100 times and hang up. We're not going to post negative things on social media about how terrible somebody is. Or how please, I want to hire somebody to come and take care of this problem for me. I'm looking for hire or something.
Take the kids out of state, or cut off the electricity, or cut off the water. But Sam, is a Polaroid picture. Isn't that what Sarah Connor at the end of the first Terminator? Didn't the kid take a picture, a Polaroid of Sarah Connor, and give it to her at the end of the movie?
It was a great Polaroid too, man. She was like really, really hot. She's a beautiful lady, good looking German Shepherd too. But that's exactly what a Polaroid is, exactly. And Bryan, so like, what's important that clients need to understand as they're contemplating, do I file, do I not? Sometimes having rules is the best thing that you could possibly do for your matter in family law. Because without rules, what people are left to is to do whatever they want. And so think about being, a lot of times what I try to tell people is when you go through a process like a divorce or a modification or a suit affecting parent-child relationship, whatever it is dealing with family, everybody sometimes will revert to their 2-year-old self. And so when you're 2, there's only a couple of things that really matter to you. One is what is yours, and what is everybody else's is still yours. And really that kind of mentality permeates really difficult cases when you talk about family law, because you talk about kids. The most important thing to you that you'll ever create usually is going to be your kids. The second thing that's going to be most important to you is the stuff that you've worked for all your life. And when you ask anybody through that process who that stuff belongs to, most of the time they're going to say, well, it belongs to me. It's mine. And so without rules, how do you control who has possession, who pays for stuff, who maintains stuff?
Speaking of rules, the last week has been the kind of an unprecedented, where the Supreme Court has, you can argue the constitutionality of some of these orders, but I know that's for another day. But what the Supreme Court basically did is said there was this big hubbub going on with, and this was a big dispute among lawyers, where the standard possession order said that spring break, it belongs to one parent from the time school lets out to the time school resumes. That's typically the expanded standard possession order for spring break visitation. So people were taking that to mean, okay, well, school's canceled, so I guess I get to hold on to the kiddo from the time school spring break lets out until the time school goes back in. And I don't know about you, Sam, but our school is not going back until the middle of April now, and it may get stretched out even longer. So people were making the argument, well, it says until school resumes, so I guess that means I could keep my child for a month. Well, not exactly, because the Supreme Court came out with, and this is the first time I've ever seen them do anything like this with related to a family case in a standard possession order. They said, with no exceptions, that standing order applies. I'm sorry, not the standing order, but the standard possession order means that the way the school calendar reads, that's what you go by. If school was supposed to go back in session on March the 20th, because that's the end of spring break, then that's when it goes, regardless of what's going on because of this natural disaster. And they're really trying to prevent people from taking advantage of this natural disaster and using it to their advantage in a custody matter.
I agree wholeheartedly, and it is unprecedented for the Supreme Court. Really, it's rare for people who practice family law to see many decisions come from the Texas Supreme Court with implications towards family law. It doesn't mean that they haven't; it's just rare. And so for them to come out with a specific order dealing with this particular issue just tells you how wide-ranging and how big the effect of these orders were in relation to COVID-19. Because, really people don't understand, like, what do I do? Because my order doesn't take into account these types of situations. The same thing for courts, Bryan. I would tell you that, one of the things that we're going to see shifting and changing in our legal profession, you and I have kind of been at the forefront of this, is, can we make the practice of law much more accessible to the public without them necessarily having to come to us? Can we bring the law to them? Well, I'm telling you that right now, courts across this entire country, specifically in Texas and Florida, because these are the places that we practice, are wrangling with that right now because courts can't just shut down. the whole process, there has to be accessibility to the legal world for, the general public. And right now, yes, it's absolutely curtailed, but they're definitely looking at. There have been orders from the Texas Supreme Court. There have been orders from the Florida Supreme Court about remote and distance practicing, right? Does that mean that we're using like medical professionals? Are we using, online technology, portal technology to allow people to log in to have, protected hearings, but while still maintaining, the protections that we want? Because we obviously know, like, not everything is secure if you're using somebody's Wi-Fi. And so like all these kinds of things are what courts and the Supreme Courts really not just at state level, but at the federal level are dealing with right now.
And also, there's a whole matter of, just the formality of court, and, certain exhibits have to be, in the courtroom and have to be, reviewed and authenticated, for evidentiary purposes and different things like that. So they're having to make orders surrounding all of that kind of stuff, because obviously you can't just hand an exhibit to a judge to review when you're not in the courtroom, obviously. So, how do those things, how do, you get a witness if you're doing a hearing remotely? How do you get a witness to review a document? I mean, those are all things that the courts are grappling with, and they're all things that the courts are going to have to solve going forward. And I think you got a lot of really, really good judges out there. You've got a lot of good judges who are using a lot of creative measures in order to get these things resolved. And one thing I have noticed is they're doing a lot more remote mediations now. And normally, the normal rule of thumb is with a mediation, you have to go into the mediator's office, or the mediator comes to you. But the idea is you have to be present, and the mediator has to be present, has to be able to speak to you, has to be able to see you, has to be able to see your attorney. But they're doing a lot more remote mediations via Skype, or whatever other means you want to use, Google Hangout, whatever it is. And that's also something that's been going on, is they've been doing a lot of that. And I've also seen a lot of issues with people offering to be private judges on cases or different things like that. So you could potentially agree to basically a private judge or something akin to an arbitration to help get your matter done faster. Although I would tell you that without a court system, we're going to have a societal breakdown. And that because if you can't get redress from the courts for, certain things that are going on, it creates a huge vacuum in our society. And I think that leads to a lot of civil unrest. So what they're trying to do is do anything they can to accommodate the situation so that we don't have a breakdown in the system, and we don't have, it's going to be justice delayed. There's no question about that. But is it going to be, it's not going to be no justice. They're going to make the proper allocations for what needs to be done.
Absolutely. And Brian, on that, so like, I guess I want our listeners to, comprehend this. Is if you have an emergency situation, you're still going to be able to get to a court. You need to get in touch with a lawyer, competent counsel. But those courts, judges, whether it be 1 or 5 or how many they're keeping on, depending on the size of your city, they are keeping personnel available for emergency situations.
Absolutely.
So if you're a victim of domestic violence, if you're a victim of child abuse, or you believe your child is being abused while in possession of another person, or the other parent, or if you feel like there's an emergency situation in relation to, a particular asset that's going to, be gone forever if you don't act, you can still get into courts. It's just there. And I'm not saying that, everybody's issues aren't important. There's just different levels of importance. And so what I would encourage, clients to consider and contemplate is this something that is immediate? Because if it's immediate, you and your lawyer really need to have that conversation, and it's very likely that you can still get relief. You can still get emergency orders. But you just got to understand that, those are going to be very narrow types of issues that a court is going to contemplate right now, because they're running on a skeleton crew. I know that in Florida, I think they're down to essential personnel only in courts, meaning that there's typically going to be maybe 1 or 2 judges who are remaining available to take any kind of emergency hearing. I know in Tarrant County,
I think in Dallas, the same thing.
Dallas County just got they just got a shelter in place order. So, if it's not one of these exigent circumstances, you're not going to get in front of a judge right now. You will later. And so that's really where our advice comes in about not waiting to file. Like, if these are issues and concerns, at least get your place in queue. I can't stress that enough. rather than waiting and then, having to really be at the end of the line and a much
Then
longer wait.
another thing that the courts have come up with is they've come up with then an effort to try to kind of assuage some of these issues. I mean, people are really suffering. I mean, people are out of jobs. People are, people especially in the service industry are really, really suffering right now because they may have gotten furloughed with 24 hours notice. Because the restaurant shut down or their companies, just can't afford to pay them right now. So one of the things that the courts are doing to kind of help in this situation is saying, look, I mean, evictions, things like that. If you're trying to evict somebody from a house, I mean, obviously it's going to stink for landlords and stuff like that potentially. But if you're trying to evict somebody from a house or an apartment, I mean, you're going to be delayed. I mean, and if you're the person on the other side of that's potentially going to be evicted, you do have some time where you're not going to lose your house. You're not going to lose the place where where you're residing, at least for a while, until I think they're saying right now, not until after April the 19th. I mean, it does suck on the back end where there'll be a big bill, but it does provide some immediate protection so that you're not being kicked out of your house.
Yeah, and I think the big part of that I would encourage clients to do is, what you don't want to do is take the ostrich approach, right? You don't want to stick your head in the sand and say, don't worry, everything is going crazy around me, but it'll be fine. By the time I lift my head up, everything will be back to normal. That's not the way you really need to address kind of the issues as they're presenting themselves to you. So as an example, if you're worried, I can't make my mortgage payment, or I'm not getting a paycheck right now, but I have a child support obligation, you really need to contact these departments, put them on notice. You know what I'm saying? Like, give them the information that you have, because if not, they're just kind of looking at, they don't know whether you're still employed or not. If you have a terrible relationship with your ex, or the father of your child, mother of your child, and you have these financial difficulties, it really behooves you to bring them into the loop, because it's never going to be an easy conversation to say like, hey, I don't have money, so you're not going to have money. But it's better at least that you have, everybody on the same page trying to get some relief. And like a lawyer has the ability to help you at least possibly get some things deferred. Maybe your loan gets extended. There's just a lot of different packages, a lot of different programs that are coming online every day, as a quickly changing situation. But every day something new is coming on to try to help people in those situations. So, you definitely want to reach out, definitely want to try to stay as informed as you can rather than just hoping.
And kind of what what Sam and I talked about earlier before we came on was basically there's going to be, this stuff is going to start coming to a head where you're talking about balancing the interests of, constitutional rights versus public well-being. So, you have all of these, county judges and different things issuing orders and saying that this is this and this is the, and they're really at this point asking people to comply. And I think, at some point they may not be asking anymore. And, I think we're fastly, if we haven't already reached that point, we're very, very close to that point. So, I think the courts are going to be filled up with cases here in the near future dealing with the constitutionality of some of these orders versus the public well-being to keep the public safe with this virus spreading rapidly.
Absolutely. And, it has family. I mean, obviously it has wide reaching implications across all areas of law that we'll touch on in future podcasts. But as far as, just the family context, Bryan, it absolutely is going to affect family law matters. And I'll just give you a simple example. I had a client who called very upset saying, hey, you know what? I've been, talking to my child's mother. We had been agreeing to, hey, limit contact to our child. And so she picked up the child, instantly went to the local convenience store, walked the child around so she could pick some stuff up, then wanted to go to do a whole bunch of shopping, took her to like 5 or 6 different stores. And he was like, the exact opposite of what we had decided to do. I want to withhold possession, or I want to immediately be able to go and shelter and protect my child. Well, during that period of time, typically under most constitutions, I would say at least in the United States, a parent is entitled to do whatever they want to with their child so long that it's safe, right? But to determine what is safe right now is very difficult. These are not federal mandates or federal recommendations. And if you happen to be living, as an example, this gentleman lives in Dallas County. Well, Dallas County has a shelter in place order. His mother lives in Tarrant County. That's about 17 miles away. In Tarrant County, there is no shelter in place order, meaning that people can still move freely around. So in that situation, you have a order that says one parent cannot go outside of their house except to go to the grocery store or to seek medical assistance. And the other parent can run around as much as they want to. 17 miles, extremely densely populated metroplex area. Do you see what I'm saying? So like you go to court and what's the court going to do with that? These are very complicated, difficult situations that courts are going to have to wrestle with as we go forward, and they absolutely have constitutional
I have a
implications.
very similar situation with a client who, well, it's not similar, but it is a situation where a client who's the mother of the child will not allow dad child because he was overseas. Well, he finished 14 days of quarantine, but she's just not comfortable with it. So, is she justified in keeping the child away from him because he might come down with the virus, or has he an amount of time of quarantine to where he should be entitled to his normal, ordinary, standard possession? I mean, that's something that's going to be probably a hot button issue for a while to come.
Oh, absolutely. I'll give you another example, Brian. And this is, I have two college age children, but my youngest is a freshman in college, and obviously spring break time just passed, and luckily I've got a really sensible child who, I think I put the fear of God in, and I was like, you're not going anywhere, and she didn't. But there were plenty of her friends who did continue to go to spring break. One of them was in Miami-Dade area. She was out at the beach with all these friends, all these huge parties. Now all of a sudden she wants to come back, and her parents are divorced, and one parent is like, well, you can't come because I've been remarried and I have younger children, and if I let you back in the house, which is her primary residence, then my husband's ex-spouse, who's the mother of the younger children that are in the house, is saying that she'll take us back to court. So what do you do in that? You're putting families in a situation where you can't let your child back in the house because instantly it's going to land you in court. But that was a risk, because obviously we know now from these people getting together in the Miami-Dade area, there are people coming back that are absolutely
five kids from the university in Florida in Tampa right now, as of yesterday, from what I read.
Exactly. And so, yes, so you can see both sides of this argument in it. Judges are going to have a very difficult time, and I think that parents are going to have a difficult time. But if you can't work it out on your own, I really want everybody to know the law is still there. Lawyers are still there. You really need to contact people. There's a lot of creative things.
And like I said, if you have, like Sam was talking about earlier, if you have absolute life and death emergencies, don't let this prevent you from getting relief from the court. You absolutely have the right to go to the court, and you absolutely have the right to get heard if you have a life and death issue. I mean, just because you think it might be a life and death issue doesn't necessarily mean that the court thinks it's a life or death issue. So you really, really need to get the advice of a competent attorney and, figure out whether that's an issue that you can get in front of the court on, because the court will hear you. Just understand that they're completely short-staffed. And but if you have an absolute life or death issue, don't let this prevent you from getting down there and getting the relief that you need, especially if it's involving children or potential harm that might come to children. It's very important that that you understand that the legal system is still working. It may be a little bit slower, but it's still working.
Absolutely, Brian. Absolutely. Just want everybody to stay safe, and we'll be out the other end of this tunnel hopefully someday soon, and we'll look back at this.
Yes, sir. Wow, so without anything else, I think we'll probably come back on in the next couple of days and talk a little bit more about this situation, because as we talked about before we came on air, this thing is ever changing. And like I said, we've had 6 orders from the Supreme Court coming out in the last week, related to this thing. So obviously this is an ever-changing thing, and the numbers keep changing every single day, and what's going on keeps changing every single day. We've got order, some places like Dallas County is shelter in place, some places just we're encouraging people to it's really, really tricky to navigate these waters right now. So, all right. Well, I appreciate your time, Sam, and we'll be back on here in the next couple of days to talk some more. But thank you so much, sir. And please, you and your family stay safe. Take care.
Ditto.
Thank you for listening, and we hope you enjoyed the Top Texas Lawyers podcast. If you would like a consultation with either Bryan or Sam, please call 1-888-981-7509 or visit us on the web at astxlegal.com. Once again, that's astxlegal.com. Thank you very much.